Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Podcast with attorney Mark Battleson of Battleson Law, LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring with a background that includes both legal work and hands-on business roles. I'm Lisa Mosbey, your host, and today we're talking about personal guarantees in Georgia business loans and leases, and what business owners may be putting at risk before they sign. Mark, thank you so much for joining me today.
Great to see you, Lisa.
Mark, what does a business owner actually agree to when signing a personal guarantee as part of a loan or commercial lease?
The reason why the personal guarantee even exists, most people seem to think that, well, if I've got an LLC, I'm doing that to try to have liability protection, primarily from third parties, but they don't. They think they can end up borrowing money or sign a lease without actually having it's a phrase I use all the time: a warm body and a beating heart, and not just a shell LLC that's brand new. The landlord and the landlord or a lender will want to make sure that they've got somebody that they can go to have actual recourse in the event of a default on a loan or a lease or other, just liability of the company that is a business choice, not a third-party liability like a slip and fall or a death at a hotel or whatever. Those would be different kinds of liability, and the LLC would generally protect individuals in that instance. But bringing it back to your question of a guarantee is you saying, kind of like a cosign on a loan or a car loan or whatever, something small, you're going to pay if the business LLC defaults in any way, shape, or form, not just that the LLC can't pay, but there could be other defaults, and then the guarantor could have liability there as well.
And why do lenders and landlords require personal guarantees in the first place, especially when the agreement is being signed by the business owner itself?
I mean, so there will be credit underwriting on the viability and security of any loan or lease with respect to the credit quality of the business. But a lot of businesses aren't 20 years in business with cash flows and assets and standing alone on their own credit, in particular small businesses where I work now. I used to do much larger corporate work, and now I work for lower middle market and small businesses down on Main Street instead of Wall Street. So the creditworthiness of a company, even when somebody that's been around for decades, may not be able to stand alone from a bank or a commercial landlord's perspective, and they're going to want somebody there that can stand behind the company, because a lot of times the company is just a corporate shell. I mean, if it's a service-based business, such as my business doesn't have a lot of assets. And I've got computers and leased space. And so it's a lot like, just a retail business, albeit I have less equipment because and I have no inventory because I'm just selling a service. So, having to sign personally, again, it goes back to, you're going to hear this throughout this entire podcast, warm body and a beating heart. They want somebody that cannot just disappear on them and wave their hands and say, sorry, it didn't work out. And they want somebody that's going to be some pain if there is a default, that even if that person doesn't have a ton of assets, that warm body and a beating heart is meaningful, because no one likes getting sued. No one wants to defend against a lawsuit. If you get a judgment against you from your personal guarantee liability, you're going to have a judgment chasing you around, possibly garnishing paychecks, garnishing bank accounts. You may have a levy on physical property that you own, or a judgment lien on real estate that you own if you if you don't handle your business properly and then end up having a personal liability through the personal guarantee. And that's why they want it. They want to be able to turn the screws on you if you're going to go into default and keep you honest.
I'm curious if there are different types of personal guarantees and how those differences affect a business owner's level of exposure.
Yeah, I mean, the most pure play different type would be whether you have co-guarantors and whether the guarantors are jointly and severally liable if you have co-guarantors. So just for an example, and then we'll get into some what's called a cap. But you know, typically a guarantor on its base level, if it's just one person, you know, they'll have an LLC, they'll sign a commercial lease or a SBA loan or any other kind of loan, and the company will be liable for that. And not even primarily, generally, the guarantor is equally liable for it. And so immediately, it's not like you got to sue and get a judgment against the LLC and then go after the guarantor. Everybody's going to get sued at once, the guarantor and the company and whoever else has taken on liability. So as far as different types of guarantees, though, a naked, simple personal guarantee, you sign a guarantee for your LLC, you're on the hook for everything that an LLC is on the hook for. Then, if you have co-guarantors, and in the ideal world for the lender or landlord, two guarantors, jointly and severally liable. So that means, hey, we, the landlord, can sue the LLC. We can sue guarantor 1 and guarantor 2, and we don't care who we get paid from. In which case, guarantor number 2 may have signed on something, but guarantor number 1 may be rich. And so they are going to enforce a judgment against the super rich guarantor 1, and guarantor 2 may get a free ride on this in the sense of the liability to the creditor. And when I say creditor, that could be a landlord as well. Then that rich guy or gal can file either a cross claim if they have been sued, or a third party claim against the other guarantor to contribute to the liability for whoever it was that did the payment. All right. So that's more of a litigation tactic, but it's just civil procedure. So then, and then this is a long answer to your question of what types of guarantees there are. But so, you know, you're going to have, and then you may be able to cap a guarantee. You say, hey, look, on a commercial lease of 10 years, I'm willing to guarantee 24 months of rent. That's it. And that's usually enough for a lot of landlords, especially after the first term. Like if it's a 2 5-year terms, one initial term, and then a 5-year option to extend, the landlord's already been made whole for any new tenant costs, tenant improvements. Same with the lender. They may allow you to cap some level of a guarantee. Lender less so, but a landlord, they've got their investment in this. You've paid rent for 5 years, and maybe your guarantee trims down to only 12 months or 24 months of rent in the event of a default on the remaining 5-year option or something like that. And so you're trying to negotiate this down to de-risk it as much as possible while still giving the creditor / landlord some level of comfort that they don't have some scumbag coming in there, or just an incompetent company, or exposed to exogenous events such as, you know, a macroeconomic downturn. They want to have protection and be able to go after somebody because they're in the business of lending money and getting paid back. This isn't, you know, free. This isn't COVID loans, which were a disaster as far as the amount of defaults on those. So, you know, these are real businesses and they want to get paid back, or they want to get paid their rent. And they've got liabilities that they have.
So I understand where you're going with the landlord and what the caps are and how that maybe a capped 24-month guarantee will protect a landlord. But how can a personal guarantee affect a business owner if the company runs into financial trouble later on?
Yeah, I mean, yeah, there may be an opportunity to cap some amount of guarantee on even a loan. And so, you know, I've run into that, you know, where, you know, father-son kind of situation where the kid didn't have the credit. Had a very sizable SBA loan in the millions, and the father came in and guaranteed $250,000 of it. And the reason for that is just they probably had some underwriting standard where they needed some better balance sheet, like asset party. And the father was like, hey, look, this is not my business. I'm willing to come in and sweeten the creditworthiness of the borrower. but I'm not willing to take unlimited exposure on this loan. And, I did a workout on that. And it was, a retail facing business with, that also had some manufactured product, and like a consumer product, beverage. And so the father, he came out of pocket and paid his son's legal fees, for me to do the workout on the business. And, it had a commercial lease, it had a loan, and, the kid was fully exposed. And I'm not a bankruptcy attorney, so I referred him to a bankruptcy attorney after we got the father's guarantee worked out and turned over the physical stuff just to be a friendly default on the loan. And the individual son ultimately filed for bankruptcy, I believe. Once it left my hands, I referred it to a colleague of mine. But we worked on that father getting out from under his guarantee and negotiating it down to a better number. And it's super complicated if the lender tries to have some gotchas in their settlement of a guarantee. You got to make sure that, hey, if you do have a cap, there's usually a lot of legalese around it, and it's not simple. And I tried to make it as simple as possible with just one line. Notwithstanding everything, in this guarantee, which exposes me to the world, this is the most amount I can possibly pay under the guarantee. And that should work. Now, if they want to litigate it, you may spend a bunch of time fighting about it, but you want to simplify it as much as possible. And then there's a lot of technical language on notices and things like that in these things that the guarantor is truly exposed. And you better monitor what's going on with the business and not just be some external third-party guarantor that doesn't pay attention to the business.
Yeah, if you don't have deep pockets and unlimited resources, they could get you.
If you have deep pockets, you're even more at risk, because then you actually have the ability to pay. I mean, I'll sign $1 billion guarantee tomorrow, and they're not going to get anywhere near that out of me. So what's the guarantee worth? My warm body and a beating heart and my, limited individual assets, but I'm not a billionaire. And so, having a guarantee if you're broke is less risky from the standpoint of what are they going to get.
For sure. I want to talk about the language a little bit. You mentioned that you try to keep it simple when you're negotiating maybe the scope or the limits of these personal guarantees. What kind of language is most important in those discussions or in those contracts?
Well, first off, you better be negotiating it early. You don't want to end up, having the loan documents drafted. They send over their form guarantee, and then you start negotiating a cap. A cap is a business term that should be negotiated during the letter of intent phase while you're shopping loans, and just say, hey, look, this is my balance sheet. Here's my underwriting, personal financial statement. Here's the business plan. Here's whatever else you're doing to get a loan or a lease. And then you say, and you want to negotiate that cap out of the gate, whatever it might be. It could be a time cap, could be a monetary amount cap, could have some level of contingencies if I'm only at risk in the event that X happens. Maybe it's a subordinated guarantee. Most of these things are not well received by a lender or a landlord. All right, let's be very clear. They're complicated to negotiate. A lot of people on leases have brokers. Some people have mortgage brokers. They are salespeople, and they are incented to get a deal done. They're not thinking about a lot of this stuff. And, that's where a lawyer comes in, to get the language right per your question. But you gotta negotiate the business terms comprehensively while you're entering into an LOI. And whether you're submitting the LOI as part of your offer or the bank, and the bank may generate their own commitment letter, but and that's going to be a one-way kind of, you're not negotiating that. But before that commitment letter is ever issued, you're negotiating with them, and maybe even through a letter of intent kind of process. So of back and forth. And that's when they're trying to win your business. They're not trying to win your business when you're on the eve of a closing and you've already got tens of thousands of dollars worth of sunk costs into pursuing this business. You don't have as much leverage then. So you got to negotiate early, and smartly and understand what you can get away with and what you can't. And each lender is different, or landlord is different as to what you can get away with. So if you're really certain on, or really wanting to be careful on this, you better shop it around and not just blindly say, hey, it's like marrying somebody on the first date. It's like, look, you got to shop around. And like the old 60s song, you better shop around. And you'll get better terms, you'll at least understand what the market is for your particular situation.
And Mark, under what circumstances can a business owner be released from the obligation later on? Do these expire? Are there terms that get to be met and the personal guarantee goes away? Can you give us a little insight onto that?
Yeah, again, obviously maturity and full payoff of a loan. Yeah, and or maturity of a lease and move out without, causing damage and everything goes well, then you're off the guarantee typically. Unless there's some crazy, past liability that you're still on the hook for, because there is some outstanding item. But it goes back to what we've been talking about, caps on time, caps on money, and making sure that when that loan is satisfied, and or this lease is satisfied, that there's some acknowledgement that the guarantee is extinguished as well. It's implicit typically within the loan because you're not taking on a separate loan. It's an obligation based upon the originating instrument, lease or loan documents such as a promissory note, security agreement, things like that. If you have posted real estate collateral as part of that guarantee or other business collateral as part of that guarantee, you want to make sure that you get not just the guarantee satisfaction identified and notified somehow in writing is best. Hey, we had a guarantee. Now the lease and or loan has been fully satisfied and the guarantee is now released. Most of the time that doesn't happen. Loan just gets paid off, lease matures, guarantor just kind of stays out there. And then you got to go to the lease and show that the final payment was made in order to not have liability. And what if you got divorced in the meantime and your spouse is running that business and you're left out there hanging in the wind, or you posted real estate collateral? You wanted to tie these things up at the end and follow up. And it's better to even have an obligation in the original lease or loan documents that requires the lender or the landlord to provide the documentation that you need in order to prove that you don't have any further liability.
Right.
And as an aside, a guarantee is what's called a contingent liability. If you have guarantee exposure, and this happens a lot in commercial real estate. I used to do a lot of apartment development, finance stuff. And let's say you're running 5 projects and you have personal guarantees on, $100 million worth of construction loans. And you have, and your balance sheet is only $5 million as a developer. And this is, bigger numbers, for example, just because I'm familiar with it. But eventually you're going to run out of guarantee capacity. You keep signing personal guarantees if you're trying to expand your business, then ultimately some lender is going to say, whoa, wait a minute. We've asked you to lay out all your assets and liabilities, and you look good there because, you got a house, you got a mortgage, you got equity in that house, you've got stocks, you've got whatever it is, cash. And then if you're not committing fraud, when they ask you the question, what are your contingent liabilities? Do you have any outstanding guarantees? If you've got $100 million worth of outstanding guarantees, it takes one of those to then cause a cascading series of defaults. If you go and get sued on one of those, it may trigger liability on all the others. And so it's very high risk if you keep stacking guarantees. Now, people do it, and it's part of, just high-risk businesses that have high returns. So it's just, you got to understand that signing a guarantee is not something to just take lightly. And there's a lot that goes into it.
Very insightful, Mark. Thank you so much for walking us through this. Bottom line, if you have these out there, maybe get with an attorney and review your current situation before signing another one. Wouldn't you agree?
Yeah. And if you're truly running a real business and or businesses, you should have your own kind of personal financial statement put together because you're going to be asked for it for lenders. And these contingent liabilities, I mean, people try to bury them from the borrower side. And if you're asked about them and you're asked for a clear picture of what all your liabilities and contingent liabilities are, if you don't disclose it, that you could be hit with a fraud claim. And you don't want that if you go into default, because you might not be able to bankrupt yourself out of that, especially if it's criminal. So, you got to be making sure that you're not committing federally insured bank fraud, right? I mean, you got to be honest on your loan applications.
That's it for today's episode of the Atlanta Business and Commercial Real Estate Law Podcast. If you're reviewing a business loan or commercial lease and want to better understand the risks tied to a personal guarantee, you can visit battlesonlaw.com to connect with Mark. Thank you so much for listening, and be sure to like, leave a review, and subscribe to the show. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.